And it is up. Welcome, everyone, to the MSP Growth Zone conversation with Daniel Whitehouse of Whitehouse Cooper. He is a MSP specific, and I mean this, MSP specific, technology focused attorney. And I have a lot of questions. So I'm accustomed to many group conversations around legal, around MSPs, around MSAs, MSAs versus contract. Is there a difference in conversation points about what those mean and so forth? So I just want to kind of give Daniel a little bit of a minute here to explain his company and talk about him, and then we'll get into some questions. So Daniel, let us know, who are you?
Thanks so much for having me, Craig. And I think I'm uniquely situated as a lawyer in this space because I come from the MSP world. I am a second career lawyer. I have a bachelor's in computer science. I worked in IT outsourcing at a small MSP level, and then later at a Fortune 500 level, doing large data center migrations on the server side. We're talking, hundreds
Oh,
and thousands of servers, both on the migration side and then also later in the management role as well. So I've had my hands in the systems. I've been on the business side of this. I also have a Master of Business Administration, an MBA. So I've been again, hands on keyboard doing what a lot of MSPs are doing, but then I've also been on running the business side, and then went to law school and now run my law firm. And we run a business as well, just like everybody else
sure.
does. So it's I'm not hands on keyboard so much to speak anymore, but I'm talking with the folks who are, and I'm translating the business risks that they're dealing with day in and day out to legal risks and how we can help mitigate those the best that we can. And what a lot of my clients tell me is that it's so nice to speak with you because we're not having to explain what our business is, how we
Sure.
operate. And
Sure.
I often have conversations where somebody calls me and says, have you ever heard of somebody doing, fill in the blank? What are the issues with it? And so we can riff on those types of conversations for
That's
for
awesome.
days on end, and help them get to where they want to be. So it's all about their growth and
Sure.
me helping them in the process.
You have spent your life in education, it sounds like.
Indeed.
Lifelong learner.
That's right. That's
Great,
right.
great. That's awesome. Uh, so let's just get into it. When we talk about MSPs, and let me break this down a bit because there is two groups out there. There are the ones that people call the break fix. They're there to support as needed, and they bill hourly and things of that nature. And then there's the true MSP, which is the recurring model, and some or many things are included in that model, maybe not everything or whatever. But should MSPs in general always use a contract for their business model?
Great question. And I'll say on your first point about the two different models, I'm seeing a lot of my clients that called me up and said, most of our clients are just break fix. We want to have a contract in place with them that establishes our roles and responsibilities between ourselves. A lot of those clients who started out in that category have evolved into the more recurring model of,
Okay.
we're doing a soup to nuts type of experience for their customers.
Sure.
And part of that has to do with, obviously there's a revenue side of this, right? So I know we're talking about legal risk and we're talking about legal concerns, but from a recurring revenue standpoint, it's guaranteed revenue. Not only guaranteed revenue, but it's forecasted staff labor. You know what your effort is going to be to support those customers on any given month. So my recommendation to them, period, is that you always have to have some form of a contract in place with your customers, even if that's to say that we will perform break fix services on a best effort basis when you call us as needed, call or ticket system or what have you. And we bill. Here's one of the things I see missing from a lot of these contracts. What are your billable increments? For example, if you're doing on-site support, which is still a very viable model, Are you charging for travel to and from the site? Is there a
Mhm.
minimum of 30 minutes travel or 1 hour travel?
Sure.
Do you have a radius that you will only travel within?
Mm.
Then you're not going beyond that, so that you don't get called 4 hours away to fix a printer.
Right, right, right. Sure,
And so, little basic questions like that come up all the time. And if you haven't spelled that out in your contract, then how do you plan to enforce it if you say, yes, I'm billing you for a minimum of 1 hour for me to drive from my office to yours? And also, does that include travel back? Is there a minimum time for that? And if you're only there for 15 minutes, do you bill for 15 minutes? Do you bill for a minimum of 30 minutes? Do you bill for a full hour, right? These are
sure,
some of the expectations that you just have to establish with your customers up front. And again, the only place to lay those out is in a contract.
sure. That makes perfect sense. When we're talking about contracts, though, what's the difference in a contract and when people say agreement? Is there a difference? And just help me out.
They're synonyms.
Okay, okay, okay,
A contract and a written agreement is the way that we would normally refer to it,
okay.
is just a signed piece of paper that you, the MSP, have signed and your customer has also signed. And there's certain components of those contracts. So meaning that there was an offer to provide services, there was consideration to provide services, that being what we're somewhat of what we were just talking about. Our
Sure.
hourly rates are X, our travel rates are Y, and our billable rates are, excuse me, our minimum billable time is Z. If you lay out those three components, you present that to the customer, they sign it, you have offer, acceptance, and consideration. Those are the three requirements for any legally binding contract that you could take to court if necessary.
Understood. So there's really not a difference, but you know, um, just people just use the terms however they choose, essentially.
What I tend to see is on the less formal side, they will
Okay.
just email the customer and say, these are the terms of our agreement, or the terms of, not a contract, meaning it's
Yeah.
not a four pay a piece of paper that has four corners. It's just that email
Right.
back and forth that says, I'm going to do this, you're going to do that. I don't accept those as being any recognizable way to
Okay.
conduct business. I
Okay.
think, if you're in business to make money and to provide a service, then you need to do yourself a favor and formalize at least some of the basics.
What is the need, or when it comes to MSPs, we deal with a lot of vendors that do like a master service agreement, an MSA that's kind of at the top of the levels. And then below that, they build contracts to kind of associate back to the MSA. Is that a common theme in the MSP space? And is that something that MSPs should consider versus just a straight contract?
Excellent question, and I love this one because it's one where we spend a lot of time. So, an MSA, or a master service agreement, is just the basic terms that are going to govern your relationship with your customer. Things like, when I send you an invoice, how long do you have to pay me for the services that I've delivered and have invoiced you for? If you don't pay me within a certain period of time, what rate of interest may I charge for
Mm.
late fees? May I charge late fees? Those types of things. These are all related in an MSA. Also, things like limitations of liability. What warranty are you offering, if any? A lot of services are provided as is with all faults, and you're not guaranteeing the effectiveness of what you're doing, because it's impossible, right? I mean,
Sure.
it's technology systems. By the time you leave their office, something has
Something's
changed.
right. Right. Correct. Right. Yeah.
So, that MSA is essentially the framework that governs the rest of the relationship. And then we'll break out statements of work, or SOWs, for things like, we're going to provide managed services on a recurring monthly basis for a period of 12, 36 months, whatever your standard is. And in this statement of work, or SOW, it defines what the characteristics are of those services we're going to provide. Then another SOW might be, oh, you need to migrate all of your systems from X operating system to Y operating system. Well, that's not included in your monthly recurring revenue.
Sure.
I'm going to develop a project for you that has certain milestones, and we will lay that out in a statement of work, and we're going to charge you this amount, or we estimate it's going to be this number of hours, or whatever those are. So special projects are always great to put in an SOW, as is that recurring revenue, but they all relate back to those primary terms in the MSA that will govern all of those further SOWs.
Is that a preferred method from your point of view?
It's my preferred method, and I nudge most of my clients to that direction.
Okay.
I have had some that say, well, we're really only going to provide for, here. Perfect example. I have a handful of MSP clients that are truly all in labor, even for
Oh,
project work. It's all included within the monthly recurring revenue amount, and
mm,
they know because they manage the life cycle of the hardware and the software and all of those sorts of things. It would be a very rare situation, maybe like a client moving locations, right, where
sure,
we have
sure.
special project work associated with that. It would be a very rare situation that something outside of their standard recurring fees would arise. But their monthly fees are obviously higher because they've factored in all of this special project work that other MSPs would normally charge separately for as a special project.
S
That particular or those particular MSPs will have just one agreement because they're not going to be using
Sure.
recurring SOWs with their customers. But outside of those rare circumstances, it's usually an MSA and an SOW.
So you make a really good point about inclusion and exclusion of sorts. Is there any legal issue with uh, bullet pointing particular exclusions or inclusions and then forgetting and leaving something off that causes the ability for you to be pushed in a situation where you cover something because you didn't put it on an exclusion list or because you didn't put it on an inclusion list? Does that make sense?
I think so. So exclusions being something like the hardware or the software must be within N-1, or
Yes, yes,
still under
yes,
vendor
correct.
support or something like that.
Or old operating systems or, something to do with, maybe it's the, HVAC systems or something associated with the server room and things of that nature.
Sure, sure. So obviously, the more specific you can be when you are creating these and you can forecast and anticipate those items, please, please, please do. But if you run into a circumstance that, like you mentioned, an HVAC system that is just so old and antiquated that it has to be upgraded, or the whole HVAC system has software behind the HVAC system has to be updated because it only works on Windows 98 or
Sure, sure, right,
what have you, right?
right,
So in that situation where the vendor and everybody else in the world is saying you have to get off of this software or else, then what I've recommended to folks is that they not just via email, but go the old fashioned route of writing something out on letterhead and describing with particularity exactly the issues that you might face with these types of risks that lay in
sure,
their customers' environments. You send that to the customer and you say, at the bottom, we can no longer provide support for this under our standard model. We can provide best effort support to the extent available, but
sure.
the vendor doesn't support this. So, we lay out all of these reasons why their customer really needs to take the initiative and perform that upgrade.
So it sounds like, my next question was really about vague or specifics in contracts. It really needs to be pretty specific.
As specific as you possibly can be.
Mm.
There's a phrase in contract drafting that if you're going to write at all, write it all.
Okay. Okay, that's fair,
So,
fair.
I mean, you may not be able to if we're writing an MSA today that's going to govern our relationship for 5 years. There very well may not be things that we can anticipate that are going to happen 5 years from now. So we can address those 5 years from today. But if we know something is coming down the pipe in 6 months to a year, well, yeah, let's go ahead and make mention of that now. For example, just something as simple as all operating systems and hardware must still be under vendor support, right? I mean, that's a very broad statement, but it really includes a lot of underlying issues that have caught folks off guard.
Sure. When it comes to the situation where there's potentially a lawsuit associated with your MSP and a client, and the need for another attorney once told me, if you ever go in front of a judge from a lawsuit's perspective and you've shown no ownership of any responsibility whatsoever, that the judge will generally run over you with a freight train.
Sure.
Instead, they suggest, and I'd like for you to kind of expand this a bit so that other MSPs can understand it. There's the belief, at least from that perspective, that you have to hold yourself to some responsibility, and then you should always include a remedy, because if there isn't a remedy, then it could be unlimited. Is that correct?
To some extent, here's the. I think what the person was referring to is you were compensated for services. You were paid to do X, Y, and Z task, and if in response to payment for those tasks, you're saying, I'm not responsible for anything. I'm just coming in to do these tasks that I've recommended to you, but I take hold no responsibility whatsoever for. Well, what have you actually accomplished here? Did you really perform your duties adequately? And so that's what we might want to look at in that
Okay.
situation instead. So
Okay.
if you say that you're going to provide antivirus and patch updates on a monthly recurring basis, and you have a system that you're charging for every month, it's part of the 100 nodes that are on this network, or part of the 10, right? Doesn't matter what the number is. But if there's some flags that you're receiving and you haven't been able to update that system from an antivirus or a patch management standpoint, but yet you still build for that every month, did you really
Mm,
do what you were supposed to do?
mm,
And later you find out that that system you haven't been able to patch it or update its antivirus because it's been so utterly infected with who
sure.
knows what that
Sure.
wasn't capable of receiving any of the future updates. Well,
Right.
did you do your diligence? Did you make any sort of reasonable inquiry with your customer as to why you weren't able to access that? Did you notify them, or was it up to
Right.
them to go and look at this system on site, and at least help you understand why you couldn't do that, right? So in that situation, if that system caused a breach on the entire network of your customer, and your response was, sorry, not responsible,
Yeah.
I couldn't access the system. Well, then you're going to take it to the next level. The court and the opposing attorneys are going to take it to the next level. Why couldn't you access that system? What did you do to access that system? Who did you tell you couldn't access that system?
Right.
What steps did you use to try to perform your responsibilities? Or did you just derelict your duties and ask to get paid regardless?
And I would say that a lot of people probably don't have anything in their agreements at all that define that. So is it kind of like a willful neglect? Like you need to be responsible for, knowing better and not doing it. That's what you're going to be held to. How does that work with vendors? So when you've got vendors that have, liabilities of their own, and you're using an RMM that gets compromised, and it's unbeknownst to you, let alone the fact it's been, it's not that long ago that it was in the news. Like, how does an MSP protect themselves when they really just redeliver solutions that are someone else's?
Great question, and this might take us on a whole different sidebar here.
Okay.
So I've unfortunately been involved with a number of those circumstances where the RMMs have been breached, and my downstream, my clients' downstream customers have been affected by those. So the simple answer is you seek indemnification from those RMM providers. However, depending on the agreements that you signed as an MSP with those RMM providers, whenever you signed up with them years and years ago, they may have zero responsibility from an indemnification standpoint. They may disclaim any and all responsibility along those lines, because there are a number of factors that can impact your ability to use their tool.
Sure.
Did you use reasonable precautions? Was it truly theirs? Now, in some of the ones that I've dealt with, it was clearly their fault, and they had counsel that came in and helped perform investigations and at least get to the point of understanding where fault really lied in those cases.
Sure.
But they may not have been required to do that,
Mhm.
interestingly enough. So, very similar to, we're talking from the perspective here, Craig, of MSPs and their customers, but these vendors are customers of the MSPs, and so be diligent in what you're signing with your vendors and what obligations they're holding to you, because again, they're taking your money every month as an MSP. So what
Sure.
are they giving you in exchange for that?
Sure. Do you ever see where your clients send whatever they're asking to be signing with their vendor to you for you to review? You have the ability to maybe communicate back and say, I'm not going to sign this because it has this in it. And vendors actually make an adjustment, or do they basically say, it is what it is. You choose to sign or not. We have enough business. We don't really care.
Most things are negotiable.
Okay. Okay.
If they want the business bad enough,
Sure.
and here's the unfortunate part. An MSP that's just starting up, that is only bringing a handful or two of nodes to that product, it doesn't have the same leverage over
Sure.
the MSP who's been in business for 5 and 10 years, and has
Right.
thousands and thousands of nodes they're bringing on. So that's a reality. But
Sure.
nevertheless, if you don't ask, you'll never get it. So
Well, that's true.
that's the lesson, I would say, for everyone out there.
Yeah, for sure. Tell me some mistakes you've seen that are so common and so simple from a legal perspective from MSPs, and not a broad range, but just, two or three or four that just can hit home for the people that are listening to say, look, I can fix that.
Yeah, you exactly what you said. Look, I can fix that. So, as technical people, we have a desire to fix problems that we see,
Yeah,
and that may include going above and beyond what's in our contract, what we should be doing. It may also include overstating the services that we're actually providing. And when I say that is, many MSPs want to be a one-stop shop for their customers. That you will never need to use another service provider because we can provide everything that you want to do. And
sure,
and it's not necessarily an ego thing. It's the desire to do right by your customer,
sure.
even if that's not in your true skill set. Perfect example of that is security. So we were talking about antivirus, we're talking about patch management, and sort of the basics of security. Well, a lot of MSPs are now offering extra security services. What does that really include? Right? Is it log monitoring? Is it some sort of intrusion detection service? Are you really just relying on a third party vendor to perform these services? And only if that third party vendor alerts you to a problem will you then alert your customer. If your skill set is not such that you've been trained and truly understand the low lying security issues that are out there, then maybe you partner with another organization that
Yeah,
specializes in nothing but security as a service, and you utilize them. They can be a subcontractor of yours, by the way, and so now
sure.
we can talk about indemnification between those two vendors.
Okay.
But maybe if that's not your core competency, and you don't want to overstate your qualifications, then you shouldn't be getting into that line of service.
And you say that's a good point, because it's something I really didn't think about, as using them as a subcontractor, because a lot of these, the security side anyway, have agents on devices that have a ton of power, and you're just hoping that they're doing the right thing anyway. So by going through the subcontracting process legally, you can assure that that doesn't cause cause you significant issues down the road because of something that they did.
That's right. And if that truly is their core competency, then they will be willing to offer indemnification for the services that they provide. They will be able to show you what exactly you're getting as a vendor of theirs, and then you're reselling to your customer.
Okay. What else do you see MSPs doing that just could be something pretty simple to fix?
This has nothing to do with fixing problems, but more along the lines of making sure your house is in order. And this is the same advice for any company, not just MSPs.
Sure.
Think about the types of insurance that your business needs, right? So most companies will get a general liability policy. General liability insurance typically just handles physical harm, meaning if one of your people is in a building and they slip and fall in that building, but for whatever reason, it's no fault of the building, your customer's building. Well, the general liability policy would in theory, if it's not a workers' comp type issue, workers'
Sure.
compensation,
Sure.
in theory, keep you harmless from those types of situations. Or if they, back into somebody else's car when they're on site, or
Right.
something along those lines, right? And it'll usually have some sort of an automobile policy as well. It does not cover somebody inadvertently deleting all the files off of a file server. General liability coverage does not do that. Your
Okay.
professional liability or errors and omissions insurance may include those types of things. And when I say may, because we were talking earlier about exclusions in
Mhm.
MSAs. Well, the exclusions in insurance policies will far exceed.
They're legit. They are legit.
They really are. They really are. So look at the policy that you're purchasing and make sure that it does cover any accidental harm that your
Yeah.
employees may cause for your customers. And then the third minimum policy that I recommend for everybody is cyber liability insurance.
Sure.
And it's sometimes can be a rider to your general liability coverage. Other times you have to go to a third party carrier to get it. But and so this is an interesting nugget as well. If your customer has a data breach and you immediately think, I'm going to call my cyber liability policy to cover it, they will turn around and deny that claim. They are not going to cover a data breach from your customer because the data breach didn't occur. Uh, little asterisks here. Let me come back to this. The data breach occurred by your customer, and even if you caused it, it's a professional liability or an errors and omissions issue. It's not a cyber liability issue because it wasn't your data. Cyber
Sure.
liability is going to cover your data.
Okay.
The asterisk caveat that we're coming back to is if you're also a hosting provider and you have your customers' data inside your environment, or perhaps even a colo facility, or subcontracted facility, then cyber liability may kick in that situation if the breach occurred at the physical server level or
Sure.
intrusion level, something along those lines.
Sure. That makes sense. Let let's get into something that I think is really somewhat comical when I see these conversations in groups regarding the agreements being 1 year, 2 year, 3 year, but then they have some sort of 30, 60, 90-day clause out. And then there's the debate back and forth as to whether the agreement's really a 1, 2, 3 or a 30, 60, 90. Uh, uh, help people understand what that really means, which way people should go with things. Like, just give us some insight from a legal perspective.
Let me start with the business side of it, if I could, Craig, because
Sure,
I
sure.
think the business side leads into how we structure the legal side.
Okay.
So, the reason that MSPs like longer term agreements is because, generally speaking, your costs are very front loaded, meaning labor costs and overhead, right? A lot of the onboarding of a client occurs within the first couple of few months, first quarter of that deal, and then it's taking you however many months thereafter to recoup and to be profitable on that agreement, or that customer that you just signed. Now, the distinction here is, if you charge an onboarding or a setup fee or something along those lines, then you don't have that same business
Sure.
dynamic of, it takes 36 months to recoup and to really have the profitability that you want, or 12 months or whatnot. Okay. So I see the 30, 60, 90-day voluntary outs used more when there is a setup fee that's
Mm,
charged up front,
sure.
because at that point, it's you if you the methodology and what folks say is, if I'm not doing a good job for you, you can leave at any point. Right
Right.
here's how you tell me you want to leave. That's it. Um, and I've already been paid for my work because you paid me for the setup fee. Okay.
Sure.
Having said that, from again, going back to the business side, 30, 60, 90-day out is not considered recurring revenue. And from a finance side, that makes a difference in the valuation of your company. I mean, 30, 60, 90 means that they are a month to month client or a quarter to quarter client, and you can only guarantee that they're going to be a client for that period of time, that from today to 30, 60, 90 out from today. Can't guarantee that they're going to continue beyond that period. So when you go to sell your business and you're looking to have your company valued, or if you're looking to acquire a company and you need some sort of line of credit with a bank or the SBA or what have you, they want to know what your business is worth, because how much assets do you have, right? These
Right.
contracts are assets of the company. And if they're only worth 30, 60, 90 days of revenue, then the value of your business is your 30 to 60, 90-day forecast, as opposed to 12, 24, 36 months. Another combination that I've seen folks do as a good faith mechanism is they'll say, all right, after the first year, then you have a 30-day out, or
Sure.
something along those lines, right? So think about your company in the longer term. And is your 5-year plan to grow it and sell it, or will you always be the owner of that company? Because all of these decisions that you make now are affecting the value down the road. I have some MSPs that say, look, I'm always going to be the owner of this company. This is my bread and butter. I love doing this. It's what I get
Sure.
up to do every day. And I look at the good faith gesture to the customer of saying, if you don't like what you're getting, then you can leave me in 30 days.
Yeah. Yeah, and that's something we've talked about internally to our MSP as well. The one thing I've got a partner that says, "Hey, let's just sell it." When it's let's make some money, get it ready and sell it. But I like to
Mhm.
find a way to make the business run by itself without
Sure.
me, and then have that forever, as long as I'm alive. And those are different mentalities and different perspectives. But at least that gives people a little bit of understanding of why they should do it the way they do it. I guess to some degree, especially in this society, that there's a likelihood that people will sign quicker, maybe, or maybe not, with the 90 days versus, oh, I don't have to be committed to this forever. So, and then they intend to stay. I don't know.
I think it all ties back to who their last MSP was.
Well, that is a really,
Right?
really good point. That is a really good point. So, over the last 6 or 7 months, I've noticed, and I've looked back at some legal things that have happened in the MSP space, and there's a particular one up north that's had a couple lawsuits that happened, and one of them I found really interesting, and I don't remember per se exactly what it said, but it was something along the lines of this MSP had the opportunity to offer something that could have mitigated the breach, but they didn't, and thus they were sued because they weren't provided or offered this said service that could have stopped that. Have you ever been in a scenario or situation where an MSP can and they can offer upgraded services, they don't, and then there's a potential for a situation where you should have told us because we rely on you as being the professional?
I will say that none of my MSP clients have been in that particular situation,
Sure.
thankfully, but I can easily see how that would arise. And oftentimes it goes back to, overselling what your core capabilities are. And if you're truly advertising as we are the one-stop shop, you can set it and forget it. You turn everything over to us for this monthly fee. You never have to think about IT again. Then absolutely, if I'm on the other side of this equation, if I'm representing a business that has been breached, the first question I ask is what is the MSP's obligations to you, right? What did they commit to do? What did they actually do? And if in the sales literature, and candidly, I've seen some contracts that flat out say we are your one-stop shop, you will never have to worry about anything IT related anymore. I think that's a big mistake. Okay,
Hmm,
for a whole bunch of reasons. Number one, you can't prevent, no MSP can prevent that very common issue of a phishing scheme, and so user enters their username and password,
sure.
in whatever hack. You can very vehemently recommend two-factor authentication to mitigate those things. And now there's some questions about how effective two-factor is, but
Right, right.
as
Yeah,
far as I know, it's still better than not using it.
that is correct. Yeah, that is correct.
But there was some stat about 80 some odd percent of the breaches that were out there were caused by phishing schemes.
Yes. Yeah.
And there's nothing that you can do to prevent somebody from being fooled by one of these schemes. Doesn't matter how many layers of protection you've added in. Yet, if you tell your customer that you'll never have to worry about security, you'll never have to worry about your IT systems, that I'm going to make it as secure as possible. Oh, sorry, total sidebar. This one drives me nuts with MSPs, and I will always correct them if I hear it. I will certify your network for fill in the
Oh,
blank, right? PCI compliance, HIPAA compliance, GLBA, or FINRA compliance, eh,
CMMC or whatever.
whatever,
Yeah.
whatever. Unless you are an auditor, you cannot certify their environment for anything.
Sure.
And I know very few MSP client, very few of my MSP clients have that type of capability in house. Okay, um, so if you have, let's say, a medical office that needs to have some sort of HIPAA compliance attestation, not a certification, but an attestation, then do yourself a service and recommend a good third party who can come in and provide an unbiased opinion,
Yep.
because they're going to find things that could lead to a HIPAA violation,
Mhm.
and then it's on both your customer and you to work through a solution. By the way, you don't have to abide by every single thing in HIPAA or PCI or something, right? You can go through a process and say, we're mitigating the risk with
Right.
this other control over here. But the MSPs should never, ever tell somebody this is how you implement, this is how your network is going to be PCI compliant. I'm going to come in and do X, Y. I mean, and I say never, but there are a handful. I think there's about 10 in the country that are certified to do those types of assessments.
Sure.
That's it. Those are the only 10 that's,
Yeah.
and,
Yeah.
and and they don't norm those 10 usually don't provide the um, monthly management either. They just want to do the assessment, and then they're going to turn it over to somebody who's going to manage and implement thereafter.
Right. Just they're just delivering the result of the
That's
review.
it. That's right.
Yeah. Yeah. So I've spent 15 years in healthcare IT for a Fortune 100 hospital, and so one of my jobs was HIPAA security,
Hmm.
and people, in the MSP space don't recognize that there's privacy associated with it too. So even if you did the security aspect, there's still things locally that you can't control that, if you're not very specific, even the fact of what you're willing to do or can do, like you get yourself in a ton of trouble. And they just, I always say people that ask the questions that don't know anything about it, but say, hey, how do I get someone HIPAA secure? You just don't, you call someone else.
That's right.
There's just too much.
That's right. And from the MSPs that are just getting into providing services for the medical community, many of them don't understand the assessments that they have to go through for their own business, for the MSP business to
Yep.
become, HIPAA compliant.
The BAA, right?
Uh, that's a bare minimum, right? I mean,
Right. Right.
BAA is just business associate agreement is the
Sure.
BAA. That's just checking the box to say yes, I acknowledge that I'm a business associate.
Right.
There's new regulations by the Office of Civil Rights that manages HIPAA that says we don't care if you signed a BAA or not. You're
You're
still a
still
business
gonna be accountable.
associate,
That's
right?
correct. That's
Exactly.
correct. Yes,
But
that
we're
is
going to
correct.
hold your client, that the medical office, responsible for failure to make you sign a BAA. But we still have the jurisdiction to reach down and hold you responsible for any failures that you implemented for
Yeah.
these customers. So I tell people, if you're just getting into the healthcare space as an MSP, number one, you need to charge more because it's
Yeah.
not the same level of service to provide a HIPAA compatible or HIPAA compliant service that it is to anyone else. And number two, you need to make sure you understand the steps to go through to have your own business checked and make sure that you've dotted all your I's and crossed those T's.
Well, I greatly appreciate all the information you provided. Is there any last thing that you want to talk about that didn't get discussed that you feel is important for MSPs to hear?
We have a disclaimer clause in all of our when I say we, my MSP clients
Sure.
have a disclaimer clause in all of their MSAs around security in particular. And
Yes.
even if they offer security services, this disclaimer clause still exists in there, and it says something to the effect of, it's twofold. Number one, we acknowledge that certain services we're providing are intended to reduce the risk of security issues on your network, and we will do our best to provide those. However, we and you, our customer, acknowledge that nothing we do will ever prevent
Mm,
all security related risks, and it specifically mentions phishing, right?
sure.
So that's the first part of it. The second part of it, and this is Craig, we could have a whole topic of discussion around this in
Sure.
itself. And going back to the HIPAA and PCI and all of those other things, okay? It says that we, the MSP, are the administrators of your policies that you provide to us, that your legal team has said these are the requirements that your business must follow in order for you to be compliant. I'm not coming in as an MSP and saying that to be, federally regulatory compliant, you must implement this, and this control. That should not be the MSP's job. And,
Okay.
again, unless you're one of those 10 in the country that
Sure.
have
Sure.
that responsibility, you can make recommendations all day long. Ways to enhance and increase the security around the network. But when it comes to stating what your customers' compliance policies are, you should draw the line there. You should say, we are implementing your policies. We're happy to engage
Sure.
with you, review your policies, make recommendations, but ultimately it's the customer's responsibility. We're implementing it for you. So we have that clause in all of our MSAs. And you asked me a question earlier that had I ever seen this type of scenario, and I immediately said no, because that clause would
Would
trigger
stop
an
that.
out.
Right. Yeah.
It triggers an out.
Do you also ask your clients to put a clause in there that says that it's highly recommended that you get first person liability, cyber liability insurance?
We do. Yes, we
Okay.
do. Yep. And
Is it a
and that's
requirement or do you just say it's highly recommended?
It's highly recommended. I haven't had any MSPs that have flat out said, I'm not going to work with a customer that refuses to get their own cyber insurance. But they're all I can control is the MSP and that what they are willing to pay for. And
Sure.
they've kind of looked at it the same, as though I have this coverage in place that helps back me up if necessary. But the customer obviously needs to do their part as well.
It does seem to be a good measuring stick, at least from this perspective, when we work with prospects and they do have a good liability policy, cyber liability policy. At least you know that they understand that this is an important area that they need to focus on. Much better than the ones that have zero policies relating to cyber liability because they still don't think it's a problem and they still don't think they have to do anything about it. So, uh,
And the ones that don't have it are probably going to be the ones that tell you they don't need to upgrade their
exactly,
computers, and they don't
exactly.
need to do this
Yeah,
update, or
right.
subscribe to this software. The nickel and dime type
Sure.
customers.
All right, 2 last questions. One, tell us how you do business, and what I mean by that is when you help MSPs, do you help them? Is it something that they pay monthly for, or is this something that they pay by the contract? What's the best method to build the right relationship to make sure that that MSPs are legally safe?
All lawyers are different in this regard, so I can tell you how we do it. But
Sure,
for those who have worked with other attorneys, the relationship may look totally different. So
sure.
just there's my
Know that.
disclaimer.
Yes.
The way that we do business is we don't operate off of a retainer basis where a lot of law firms, you have to bring $5,000 or $25,000 to the table before they even take you on as a client. We don't
Sure.
work that way. I don't want to hold on to your money any longer than I have to. So what I tell people is, when we start to work together, that we do ask for some portion of the fees up front, because that tells me that you're serious about working with us. It's my
Right.
commitment back to you that we're serious about working for you. But after that amount, we're never asking you for any more upfront money. We invoice for on a monthly basis for whatever services we provide for you. And
Okay.
if that means we don't work together for 6 months because you haven't had any questions or issues, then good for you. I haven't held on to your money any longer than I needed to.
Sure.
So we invoice monthly for that. And, 20-day terms for payment thereafter.
Sure.
As long as the
Sure.
bills keep getting paid, we're
Right, right.
still available to work with you going forward.
So I do have a good attorney friend, and it's quite profound the number of people. And of course, they're not in this space, but they're in more criminal and stuff. It's quite profound the number of people that still owe their attorney. And I think that's the last person you ever want to, like you want to make sure he's always paid first. Like,
No comment.
right. So how do people get a hold of you?
The best and easiest way is through our website, whitehouse-cooper.com.
Okay.
We're also on the major social media. We're not on Instagram. We don't do a whole lot with the photo
Sure.
side, but we do have a Facebook page and we do have a Twitter account that is sometimes active, sometimes not. Just again, depending on how many things are out there in the world to be talking about.
Well, I can tell you the first introduction I had to you was through the form on your page, and your response was incredibly fast. I was
Ah,
I was I was surprised actually. So
and that comes everybody in the firm is understands the IT industry, and as we talked about earlier, where tech people like to solve problems, right? And so
sure,
if somebody needs assistance from you, then you solve their problem, right? And
sure.
the other thing with tech people is we try to solve them fast. We don't want to sit on problems and have this very long to-do list to deal with, and I'm the same way.
Well, I can appreciate the tenderness. I appreciate your time, and hopefully we'll have you back. We'll have another conversation about one of those rabbit holes we sort of started up earlier. But I do appreciate it, and for all the MSPs out there, make sure you're talking to someone. And if you don't know someone to talk to, reach out to Daniel over at his group and make sure you get yourself taken care of. Thanks a lot. I appreciate it.